Thank you, Chairman. Thank you to the witnesses for being here. Professor Rubin, the history and tradition of fact-finding in the American judicial system is that it's done at the trial court level, and where the rare challenge, successful challenge to the very tough, clearly erroneous standard is made on appeal, then an ordinary way to resolve that is to send the case back to the district court for fact-finding, where fact-finding belongs. I've had a hearing in my court's subcommittee on this Supreme Court's recent penchant for appellate fact-finding. Some of the prominent cases have been Shelby County, where they made the finding that nobody had anything to worry about from the freed legislatures, that conditions had changed, and then, of course, immediately you saw a case come up in which federal judges said this is targeted with surgical precision at minority voters, completely discrediting the spontaneous fact-finding by the court. Citizens United was another one. They said that don't worry about it. All the unlimited spending we're going to unleash is going to be independent of candidates, and it's going to be transparent. And a couple of $1 billion of dark money, non-transparent funding later, we know perfectly well that that fact-finding was false. So this seems to be an increasing trend. And I noticed in the Bruen case, there was a lot of fact-finding done in the context of defining what the true history and tradition were. A lot of historians to look at that and said that is junk history, that is not real. It had not come up through any kind of an adversarial process. It was not tested in the different layers of review. It was just made up by the Supreme Court justices. Could you talk a little bit about the dangers of appellate fact-finding in terms of how it permits ambitious and activist courts to run a bit wild if they're not constrained any longer to facts as found through the traditional history and tradition of judicial fact-finding in lower courts and through adversarial process?
Thank you, Senator. So Bruen has transformed the way that litigation looks, transformed from before Bruen was decided when a more conventional approach applied. Now one of the things that we're seeing is that historians are getting retained by the parties. In fact, courts themselves are asking litigants whether or not they should retain their own independent historian to help them parse the historical facts. And one of the challenges that comes up, as you mentioned, is what happens on appeal, especially if a court on appeal is doing historical fact-finding that subsequently is determined to be erroneous. Are lower courts then bound by that erroneous historical determination when ordinarily there would be a route to appeal and challenge it? So this is transforming the way that litigation is looking.
I think it needs to transform a good deal, because if you have an appellate decision that stands on what events have proven to be utterly false facts, and the appellate court hasn't gone back and cleaned up its clear error, then it becomes incumbent on the lower courts to take a look at that and see if it really makes sense, because Marbury v. Madison says that it's the job of the Supreme Court to decide what the law is. It has no particular expertise with respect to the facts. In fact, it's probably the worst part of government to make decisions about the facts, given the constraints on briefing and so forth. So thank you for that observation. The other thing that was notable about Bruen was that 12 NRA-funded Amici showed up, and the funding disclosures at the Supreme Court have been a continuing source of frustration. The Judicial Conference is now looking at that, and I hope we'll be putting out a report fairly soon. But what is the danger if other parties and the public and the judges don't have a true and accurate description of who is really behind an amicus group that shows up in court, particularly as regards coordination of multiple amici?
Senator, I think that it's important to understand who is filing different briefs, just in terms of assessing whether or not there are any particular biases with the briefs that are getting filed.
Motive matters, right? Thanks, Chairman.